Great. Good morning, everyone. We're just going to wait a little bit longer so everyone gets in from the waiting room. And that seems like everyone's in, or they will catch up. Good morning. Happy Wednesday. I hope everyone survived the last few days of extreme heat. So just jumping into it, we'll start out with our Zoom housekeeping. As usual, please stay muted unless you have a question. And if you want to participate or ask questions, there is a chat box usually at the bottom of your screen. This is where you can submit questions during the Q&A. It might be flashing because Chelsea just put in some information and some links. So if you have any questions, feel free to put them there. We will try to get to them. We have a fair amount of questions because of the break we took last week, but we will try to get to what we can. If we don't get to it, you can always email it to info@condolaw.net for next week. As we say every week, that this is general information. It is not legal advice. It shouldn't be used as legal advice. And if you have any legal questions, you should contact your association attorney. Please keep in mind that the chat function is for questions and requests for clarification, and commentary in the chat is not legal advice, and it shouldn't be used as a discussion portal like the CAI messaging boards. We will continue to update you on the CTA. It is still being challenged by National CAI, and we recommend waiting until later this year to comply so we can see how that case moves through the courts. And finally, there is no Q&A on August 14th. So enjoy your whatever you're doing on August 14th. All right, with that, we will just jump into it. And the first question we have today is, can a community currently under the Condo Act elect to adopt State Bill 5796 prior to the effective date of January 1st, 2028? And the short answer is yes. Any community not currently subject to RCW 6490, which is WUCIOA, and there were changes in State Bill 5796 that became effective, you could adopt all of that now. You've been able to do this since 2018. And if you want to do it, you would follow the procedure set out in RCW 6490-095 subsection 3. It requires an amendment to the association's current declaration to adopt RCW 6490 as the governing statute. And if the statute sets out a different procedure for how to adopt it. So the amendment will pass with if no less than 30% of the people participate, and as long as those 67% of the participants approve the amendment. So if you're a community with 100% approval requirement to amend the declaration, you can amend your governing documents to adopt WUCIOA with a lower threshold. Ken, do you have anything to add to that?
No, it's pretty straightforward. So question 2, what is the proper way to do an amendment to the CC&Rs? Should the amendment be a separate document, or should the change be incorporated into the body of the CC&Rs with a note citing the date of the change? So the short answer is that any amendment needs to be recorded with the county in order to be effective. It's usually a separate short document because of the cost involved with trying to rewrite a whole document. It also is easier for your members to understand a single topic that they're voting on instead of trying to review what might be a 20 to 60 page long document for your particular community. So it's usually easier to get a single purpose amendment passed by your membership. Certainly it's nice to have a single document, which is often called a restated declaration of CC&Rs or a restated declaration of condominium, because then you're not having to reference multiple documents. So we have some clients who have, I'll say, falsely believe that if they retype their document and print it with the edits that have been made, that that counts as a revised declaration. And it's only true if it's been voted on by the membership and recorded with the county. So it's really up to the community whether you want to try and revise the entire document. There's no need to actually put a specific date for one paragraph or another paragraph. I suppose it's not harmful to do that if you want to do that, but usually the date of recording of the entire document is what is going to control all of the text. Anything you want to add, Katie?
Nope, but more about restatements. The next question is, should a restatement of the CC&Rs and bylaws be done by a board or by an HOA attorney? So our recommendation is if you're doing a restatement, it should be done with an association attorney who knows what they're doing. It will also require board involvement. The board gets to determine what substantive changes you are looking to make, while the attorney recommended a community association attorney would draft the amendment to give effect to those changes. The association attorney, even one who doesn't practice in community association law, especially one who doesn't practice in community association law, can make mistakes that are pretty big and may conflict with the statute, which is why we recommend a community association attorney to help draft those documents. Because, and this is, I think, Valerie's favorite saying from her mama, just because you can doesn't mean you should. So a board could draft these documents, and we see it, it's pretty common, but there are usually mistakes, and we have to go back and tell them why something is not effective or why they couldn't do it. So it's probably better to just pay to get it right the first time and work with your association attorney to make sure it has everything that you want for your community. Anything to add, Ken?
Yeah, I would just say it's important to have an attorney review it to make sure you're not adopting a provision in your document which is prohibited by statute. For example, a CC&R which prohibits the installation of solar panels would be contrary to the state law adopted requiring you to allow solar panels. So the WUCIOA statute and the homeowner association statute and the condo statutes all have been amended significantly over the last 4 years. And it's hard to remember or know what all those revisions are if it's not something you're practicing every day. Next question, is it legal for a property management company to send personal owner account information to a board of directors, personal electronic email accounts without owner permission, protection, and no encryption, policy or procedure in sending personal data? So our first thought is that this question is written looking for us to say that the manager's done something wrong, and we don't have enough information to know if that's true or not. If the board is required to make decisions about the community, which it is, and it needs information about owner accounts to make those decisions, such as, collections questions or related to payments, then the board members are going to need the account information from owners. I don't know enough about the particular emails, but I would say usually I wouldn't see a problem with sending information to the board members' email accounts. I would say as a general rule, we would prefer that all associations use communication methods which have some security involved with them. And I can't comment on what is or is not in place for any particular board member. But it is certainly appropriate for board members to receive owner account information in order to make the decisions that are required of them. Anything you want to add, Katie?
Nope. So next question is, if an association has reserve funds in a CD, is the interest earned also reserve funds, or can it be distributed to the operating budget? And our first response is consider checking with your accountant for tax implications, but it might be better to leave the reserve funds, at least put some of the money in your reserve account. But you can always start with how, like, putting the interest in the operating account and then shifting it to the reserve account once you don't need that money. The board has the discretion during the year to determine how to transfer reserves, but there can be a process if you're taking reserves for non-reserve accounts or for non-reserve expenses. So the board can decide what to do, but I think you may want to check with your CPA, see how they characterize the income and go from there. Ken, do you want to add anything to that?
Yeah, most reserve study professionals are going to treat the interest which they calculate you will earn on your reserves as being reserve funds. And we had a question from a client about the taxes associated with that interest, because I guess the way they were doing it, the interest was going into reserve funds, but because they had to pay 30% tax on the interest, they were short in their operating budget on their ability to pay the taxes. And so that's an accounting question that we think should be something you can work out with your your tax accountant. Next question. If an association's CC&Rs require 100% of a vote by all owners, but the RCWs say 67%, which one has the greatest weight? Okay. So the answer is usually that the statutes say 67% or any greater number required by the documents. And so for Condo Act and the Homeowner Association Act and the Horizontal Property Regime Act, those all set a minimum. And then there's the exception where you need 100% to change the percentage ownership interest for the units. WUCIOA makes a cap on how high the percentage can be for most things, where it says you can have a percentage no less than 67%, but it not greater than 90%. And WUCIOA also sets out procedures so that if you have one objecting owner, you can get around that. And I'm not going to get into details on it, but it recognizes that there are situations where an unreasonable owner is preventing the association where the vast majority of people want to do something. And so WUCIOA sets out procedures where you can get the amendments done over the objection of one owner. So if you've got more detail on that, you need to talk to an attorney who understands the voting and amendment process for WUCIOA. Anything to add, Katie?
Nope. So the next question is, if there are 3 board members, 2 who don't follow protocol and are not acting in the best interest of the association, what can the concerned board member do? So not speaking to any specific situation, in general, if you feel like your fellow board members are not doing the right thing, you can always talk to them. Open a dialogue and try and educate them on their duty of care. If they're new board members, they just may not know. Owners can also vote to remove board members if they are dissatisfied with what is going on or if they don't think that they're acting in the best interest of the association. Your bylaws may have provisions for removal, like if a board member is not attending a meeting or not being responsive, but those are usually newer terms. If you're an older community and you haven't amended your bylaws, those may not exist. You could also consider adopting a code of ethics. That won't provide any enforcement power or ability to remove board members, but it will help set expectations and guide people on how to act appropriately. Ken, anything to add?
Well, the idea that board members are not acting in the best interest of the association ends up becoming a matter of opinion. And so the fact that you have a different opinion about what's in the best interest of the community does not automatically make the other board members failing to meet their obligation, because they may believe what's in the best interest of the community is different than what you believe. So you need to keep that in mind. And it's certainly possible for board members to have disagreements while everyone is acting in compliance with their duty of care. So the next question is, if there are 5 board members, how much money should be budgeted for board education? So it's a great question, because I would like to see boards budget for education of their members. I rarely see that. But it really depends on how much education is needed. If you've got, brand new members to the board who have no idea what they're doing, then it might be worth budgeting more. I would like to see something on the order of a couple $100 per board member, so that you could buy membership in the Washington chapter of Community Association Institute, and that would buy attendance for the board members at events like CA Day or the Law and Manager Conference, which was just held a couple of months ago. It would also allow for participation in the National CAI message board, so that board members could get education from National CAI. I've seen some clients which have actually budgeted as much as $1,000 a board member, because you can pay for educational programs which are a full day long, which CAI puts on every year. But again, we don't see much of this because our board members are frugal. Anything you want to add, Katie?
Nope. So the next question is, can you please describe the best practices to conduct secret ballot voting in a Zoom meeting? I understand how to conduct it by paper ballot, for example, assign a unique ID to each ballot to know the ballot has not been duplicated, but I do not understand how to collect secret votes from owners present in a Zoom meeting. Secret means secret from whom? Can the management company know the owner's identity when they vote? So first, we don't know if there's a best practice for secret ballots during a Zoom meeting yet, because of how WUCIOA was written and changed about a month ago. So if you're a WUCIOA community, there was a change on June 6, 2024, which basically says that owners have to be sent a ballot when the meeting notice is sent out. You cannot require owners to vote via electronic means unless they sign a document or send an email saying that they opt in to vote electronically, or if they actually end up voting electronically. And so we don't think that you can require owners to vote electronically, especially under how the statute was written. So at the very least, you need to also offer an absentee ballot. And it may mean that for secret voting or secret ballots, it ends up being a 2-step process. If you have to take nominations from the floor, then you have a meeting and then you have an election by mail. So all of that being said, there are things to keep in mind if you're a WUCIOA community, and for all communities in 3 years, about secret ballots, because WUCIOA requires that secret ballots are used for elections, removal of board members, amendments to the governing documents, and incorporation of common elements to limited common elements. All of that being said, there may be ways to use a company like Votegrity, or I forgot what the other one is called, but there are electronic voting companies. We don't know how they handle the secret ballot voting, but there's probably some unique identifier or something with a code where they can tell who's voting and how it's calculated. So there is probably a way to do online voting with a unique identifier, and you can probably send a link and have it open while the meeting's taking place. You couldn't do it with something like SurveyMonkey, because you wouldn't be able to tell whose allocated interest is associated with what. And that also means that someone needs to know how people are voting. So it could be the manager who, it's not going to be secret from everyone. The manager may know because they have the unique identifiers and they need to calculate it. If you're a self-managed association, it'll probably be the board secretary who who knows the votes, or you could have a teller of the election, or there's California requires it, and I can't remember what it's called, but basically a surveyor of election or something like that, where it's a third party who comes in and determines the ballots and casts the votes. So someone will know. It can be the manager. It's mostly that the ballots are secret from the other owners. And WSCAI and CAI may have more information about electronic voting companies and how to use them for the best of your association. Ken, do you have anything to add?
Yeah, I'm sure that some conspiracy theorists got the legislature to make edits to the voting requirements in WUCIOA. And some of them, we just don't know what it means to comply. So the association is now required to implement reasonable measures to verify that the ballots cast are cast by the unit owner having the right to do so. And so we don't know how you're supposed to do that with either paper or electronic ballots. So you got to come up with something. And as Katie said, also, you cannot require electronic voting under the way the statute is currently written. You have to also send out a ballot so that owners can cast a ballot with a piece of paper if they want to. So this is going to be evolving over time, and it's going to be a problem as we get into the next election cycle, because some people are going to read this and want to know how you verified the votes. Next question. What information does condo law have with regard to the clean building bill in Washington State? So the short answer is that we have not been involved much with this. The bill is designed to try and make the existing buildings less reliant on fossil fuels. It is setting up standards for reporting. The first group of buildings which are required to report don't have to begin reporting until 2026, and that's for commercial buildings and hotels and dormitories over 50,000 square feet. It does not include multifamily housing until you're bigger than 220,000 square feet, which is a big community. That would be 220 units over 1,000 square feet each. And the second tier, which is buildings of 50,000 square feet each and does include multifamily, so condos would count, those would begin reporting in July of 2027. And so there's a couple of links. Maybe Chelsea can put them into the chat for you with frequently asked questions, but this is not something which our office has been involved with at this point. So, Katie?
All right. Next question is, the recent article in Common Ground WSCAI's magazine indicates that the requirement to comply with the Corporate Transparency Act are still in place, and that board members will be able to apply for their own FinCEN number to be included in the HOA filing by December 31st, 2024. If a board member refuses to provide a FinCEN number or provide their documentation to the HOA, are they disqualified as board members for the association? And maybe. It's a very lawyer answer. We don't know yet. For many bylaws, complying with state or federal regulations is not a qualification of being a board member. Your bylaws could be amended to require this. But there's also an argument that failing to comply with these regulations is a violation of the duty of care. So ultimately, if a board member does not want to provide their information as required by the Corporate Transparency Act or create a FinCEN number, they should consider stepping down from the board. If they don't, owners could vote to remove them. This is important because there may be financial penalties for both the organization and the board members if they fail to comply. So in your next election cycle, for anyone considering running for the board, it might be worth telling people they either need to get a FinCEN number, which if you have a TSA, if you have TSA pre-check or some of these other things, it's apparently easier to get a FinCEN number because they already have the information. But the FinCEN number is, I'm not quite sure what it stands for, but it's some unique identifier for like the Treasury that identifies you as a person. I think it's something similar to like your it's not like a social security number, but like and it's not a tax number, but it's just a number, so you don't have to provide your birth certificate and all the forms of identification that are required to provide as a board member to comply with the CTA. Ken, anything to add?
Yeah, the FinCEN number issue is important if a board member does not want their fellow board or owners to have the information about them. So you don't have to give the association your address, birthday, social security number, all those things. Because if you give it to the federal government directly, the association can just reference that number. That's what the FinCEN number is. So that if your concern is you don't want your neighbors to know any information about you, you're allowed to prevent the neighbors knowing. You're just required to give the information to the federal government. And I think we saw a report that said something like 132 million people are going to end up in this database under the federal government. And it's something which right now the federal government is making lots of threats about big financial penalties, like $500 a day. And so they are pushing it hard, which is part of why there have been lawsuits to try and overturn it. But so far, the law is still in place. Number 12, are units within a sub-association required to get a resale certificate from the master association? And this says it's also a association governed by the Condominium Act. So without knowing more, our answer would be yes. If the master association is subject to the statute, a resale certificate is required. The master association resale certificate may be shorter than the sub-association. It also depends on whether or not you're paying dues separately to the master and to the sub-association. Well, we have some communities where we know there's a master and a sub, and they have two separate distinct resale certificates. And we have other communities where there's a master and a sub where they have a combined single resale certificate that provides the information for both of the two associations. And I don't know that one is preferable to the other. I do know that at least one of the clients, the owners end up paying for two resale certificates because two are being produced. And they think that's unfair, but it is part of the community they purchased into. So another thing I will also note is that under WUCIOA, all communities, including the homeowner associations, which have no requirement for resale certificates today, under WUCIOA, they will have a resale certificate requirement effective on 1/1 of 2028. Anything you want to add, Katie?
Nope. So if a condominium association allows its community clubhouse to be used for food prep demonstration by an owner as part of her business, does that make the building a place of public accommodation for the ADA? The attendees do not have to be condominium residents, and most may be non-residents, and we don't know if she's charging for those attending. So this question is too specific for us to answer, and we recommend consulting with your association attorney. We think there could be an argument that by holding the cooking class open to the public, that the clubhouse is a place of public accommodation because it's either a place of public gathering or it's an establishment that serves food like a bar or restaurant. Places of public accommodation are facilities operated by a private entity whose operations affect commerce. So if someone's operating a business and having classes that could be affecting commerce. We can't say without more information if a court would find that her food demonstration operation affects commerce and thus makes the clubhouse a place of public accommodation subject to the ADA. And this is why we recommend you consult with your association attorney. Anything to add, Ken?
Well, I would add that for the most part, the Justice Department, which is who enforces the ADA, is leaning towards finding things to be public accommodation because they think the purpose of the law was to make all of the world more accessible. So there's certainly a risk that if someone were to complain to the Department of Housing and Urban Development or to the Justice Department, they would decide it was a public accommodation just because they want to support the disabled. And I guess I would also, have questions about whether or not an association should be letting a common element be used as a place of business for their members or non-members. But that's not the question that was asked.
What also made me think of, if we're preparing food, that brings in a whole different issue of like serving food to people and whatnot. So there's probably more there that someone should look into.
Well, yes, you could have health department issues.
Right.
Because if there's not a 3-compartment sink for the food preparation and cleanup, maybe you're violating some health code. So anyway, next question. If an HOA's dues are too low to meet the $2,000 minimum threshold for foreclosure before the statute of limitations kicks in, and you get a small claims judgment, will that extend the statute of limitations? And the answer is no, because the small claims judgment is not an assessment. And so if your dues are only $100 a year and the statute of limitations is 6 years, you're right. You will never get to the point where you can foreclose on their home. It doesn't mean you can't still use the courts to try and get a judgment, which could lead to a garnishment on their wages or their bank accounts. There are other ways to deal with it, but at least, our opinion is that you're not going to get to double up on the assessments by collecting a small claims court judgment. You want to add anything on that?
Nope. So can WUCIOA be used to shift common element damage expenses onto the unit owner's insurance? This is only if the owner causes the damage through misconduct or negligence. Can you use WUCIOA to shift common element damage to the unit owner? And it should also be stated in the declaration as well. We don't think you can rely on the statute alone to do this. If there is no misconduct and no negligence, then the association is responsible for the damage to the common elements. Anything to add, Ken?
Yeah, WUCIOA was just amended again in June to require that if you are going to be able to shift an expense to an owner, that has to be stated in plain language in the governing documents, meaning in the condo or CC&Rs, the condo declaration CC&Rs. Apparently, the legislature was feeling like owners were not getting adequate notice. They were being surprised by these assessments for damage. And so there's now a requirement that it be stated plainly in the declaration that you may be responsible for charges. And also you're required to give notice and an opportunity to be heard to the owner before you can assess the costs to them. And so these are procedural issues which you're going to have to be cautious about following, even if you have an insurance deductible shifting amendment already in place. Anything to add, Katie?
Nope.
That was your question. All right. So next question is, how do changes in RCW 60.30 relating to holding back 5% of construction projects affect common interest communities, especially condominiums? We see 10% holdbacks on contracts for our condo common area projects, and this statute reduces it from 10% to 5%. Or are projects in our communities not construction projects? So you can go to the legislative website and get a summary of what this statute is. And it is specific to money which is being held back from suppliers and subcontractors on construction projects. And basically says you can't hold more than 5% for work that's already been completed. And that if you don't pay that 5% when it's due at the end of the project, you have to pay interest to the contractor or supplier. And it's intended to protect contractors and suppliers from having builders use them to finance projects. I don't think there is any exempt condo or common interest community, because the only exception on this statute is for construction of single-family residential homes. And if you're a single-family home community, you are not constructing new homes. You may be repairing common elements, but you're not going to be exempt. I don't see this as particularly significant. I think 5% is standard as retention on most of the larger construction contracts we work on construction contracts for. So I sort of think of this as a non-event. But, if you're using 10% now, you need to switch it to 5%. Katie?
All right, next one. RSW 6438045 4M says the following: an association must retain copies of all notices provided to owners or the association in accordance with this chapter or the governing documents. What notices does this article refer to? For example, if it is an annual meeting notice to 475 homeowners, do we need to store all 475 letters or only one copy of the letter? So first, the statute refers to any notice required by either your governing documents or the statute is something you should keep. So if a notice sent because it's required by statute for a budget ratification or by your governing documents for an election, all of those are something you should keep. But you only need to keep one copy of the notice, as long as it's the same notice that was sent to everyone. So if you're sending a notice for a violation to one owner, you should keep a copy of that notice, but you don't need to keep 475 copies of the same notice. Anything to add, Ken?
I would add that at least my recommendation would be you also have a copy of the mailing list that you used to send the notice. So the mailing list is going to be changing routinely throughout the year as ownership changes. So the day you send out the mailing list, you're going to have you should have a copy of the 475 owners' names and mailing addresses that you used, because the two documents combined would be your ability to prove that notice was sent to a particular owner. Next question. If homeowners associations created in 1996 are governed by the Nonprofit Corporation Statute, RCW 2403, has this statute changed to WUCIOA, or is there a different RCW? So a couple things. There are two kinds of statutes that apply to all common interest communities. One relates to the property, and that's the Homeowner Association Act or the Condominium Act or WUCIOA. And the other is a nonprofit corporation statute that will apply to an association only if the property statute does not address something. So you only would look to the nonprofit corporation statute if your common interest community statute is silent on a subject. So if you're talking about voting, for example, the statutes for voting and WUCIOA and Homeowner Association Act are very detailed. You should not need to go look at the nonprofit corporation statute. But if there's something missing, you would go to the nonprofit corporation statute. And there are two of them, so you have to be careful which one you're using. Also, I'll note that 2403, which is the Nonprofit Corporation Act, was replaced by an entirely new nonprofit corporation statute, now 2403A. So that's what you'd be looking at now. So basically, the common interest community statutes are controlling. You only look to the others to supplement if needed. Anything you want to add, Katie?
The only thing I'd add is that 2403A is not affected by WUCIOA, meaning WUCIOA's adoption and effectiveness will not change the other statute. Okay, the next one is a homeowners association required by law to amend their governing documents, bylaws, and declaration every 20 years? Is there a law pertaining to this? No, an association is not required by law to amend their governing documents every 20 years, and there is no law that addresses that. But that doesn't mean that you shouldn't. We recommend reviewing both documents yearly, maybe every other year, to determine if changes need to be made. If your documents are more than 20 years old, it may be appropriate to amend them to make them consistent with the current statute or even WUCIOA and other best practices. There have been a lot of changes over the past 20 years within the industry and the statutes that at least you could amend them to be more consistent with the law as it is and best practices. But you should, at the very least, review them to determine if any changes need to be made. Anything to add, Ken?
Yeah, you might want to create a cheat sheet of the statutes which you're required to follow, even though they are not included in your governing documents. So that might relate to things like budget ratification or reserve studies or voting. One of the reasons to update the documents is just to incorporate the changes in the law. But, you know, we're learning recently that the legislature can make changes every year. And I would say none of our clients are going to try and go through and update their bylaws and their declarations to try and keep up with every change. You know, because the legislature, even in statutes outside of WUCIOA, is making changes like, you know, the requirement, or the, let's see, they adopted a statute effective last month that no homeowner association can regulate the number of unrelated persons living in a home. And that's contrary to a lot of condo association and homeowner association documents. And it didn't make its way into WUCIOA, even though WUCIOA was amended last month. So next question. Are there legal requirements in place for a condominium built in 1978 to install ADA compliant access exterior entry doors to the building? So we'll first offer this, you know, we have to know more about the specifics of your building. But we will offer that the ADA, the American with Disabilities Act, doesn't apply to private buildings like condominiums in most circumstances. The Fair Housing Act does apply to buildings, and the Fair Housing Act does have some requirements for accessibility. But most of those do not have to be made if your building was compliant when it was constructed with the law at the time. But it's a very different question if someone were to come and ask for an accommodation for a disability and ask the board to install different doors so that they would have access to their home. So that's a question that you probably would have to present to your attorney. And it is a very fact-specific analysis. The owner has to demonstrate that they have a disability, that the modification that they're requesting is going to assist them in living with that disability. And then because it's a modification of the common elements, there has to be a balance about what the cost would be to the community and what the benefit is to not just that owner, but the rest of the community. So the courts have held that if the cost of a requested modification is modest, that the association would be required to just do it at association expense. But if the cost was significant, like adding a ramp to access a door, that they could require that the individual owner pay for it. So it's very fact specific. Anything you want to add, Katie?
Nope. So the next one is, are boards bound to enforce rules and regulations that have been approved by homeowners? If they are and they don't, what can a homeowner do? So first, the board can only enforce violations that they know about. So if someone's violating a rule and the board doesn't know about it, they can't be expected to do anything. But even if they do know about it, the board has discretion when taking enforcement action and can determine that enforcement is not in the best interest of the association for various reasons. RCW 6490, 405, subsection 7, 8, and 9, which those reflect a court's, and we think those would reflect a court interpretation of when the board has an obligation to enforce. And part of it says basically if it's not in the best financial interest of the association, and it lists a bunch of other options. If an owner's unhappy about what their neighbor's doing, they can take legal action to enforce the governing documents independently of the board. And owners could remove the board members and elect a new board if they don't think that the board is enforcing the rules and regulations. And I will put the RCW in the chat because it just popped up, but another thing I'd like to add is, unless your documents require it, owners don't approve the rules. The board gets to adopt and enforce the rules. If you're a UCIOA community or there's another provision in your declaration, owners have an opportunity to comment on the rules, but unlike amendments to the declaration or the bylaws, the rules are not approved by owners. Anything to add, Ken?
The rules just have to be consistent with the governing documents, so no, I think you're good. Next question, what resources are available that would help my association identify differences between the Condominium Act and UCIOA? And I'll offer that we had put together back in 2019 some charts that are probably still available on our website that show the differences between the Condo Act and UCIOA. But there have been so many revisions to both UCIOA and the Condominium Act since 2019 that I don't know that I trust that anymore. So there's a chance that the WSCAI chapter has some kind of a resource. I'm not aware of one. And our office has not put one together since the legislature made its most recent changes. I mean, the bill that they passed called UCIOA for All was 197 pages long. And we are working just to track the changes from old UCIOA to new UCIOA and make sure we're getting them all right. We're for the most part not looking at the differences between the Condo Act and UCIOA anymore. At this point, most of our clients are just shifting to UCIOA early if they are rewriting their documents. I do have some clients who are holding on to their old statute as long as they can, sometimes because of them not wanting to have to hold open meetings, sometimes because they don't want to have to do audits and their budget exceeds $50,000 a year. There can be a couple other reasons, but I'm sorry I can't help you more with that particular question. Katie?
That is all of the questions we had submitted before, so it looks like we can get to some from the chat. Chelsea, were any sent directly to you?
No, not directly to me.
Okay.
It looks like there's just one.
I see, I can read it if you want.
Okay.
Our board met in closed session to discuss allegations of harassment by one member versus another. Does the board have a requirement to inform the person against whom the allegations were made? What recourse does this member have if the allegations are frivolous? Several members and trustees are using this technique to discredit the member without the member having the opportunity to respond. Does the community deserve to know both sides of any alleged conflict? I
don't think we can answer this
don't
question.
either. Okay. So the next one is we recently had our annual membership meeting. Our secretary announced that the meeting would be recorded to be used to make accurate minutes of the meeting. Does a member have the right to request a copy of the recording prior to it being destroyed? I think maybe. I don't think it's the full record of the association because only the meeting because only the minutes are the reflection of the meeting and what occurred. But I think you could make an argument that it's still a record. Ken, do you want
I'm going to offer the counter argument that if the secretary is recording it for the secretary's own use to draft the minutes, it is not a record of the association. The written document that the secretary prepares, which is the minutes of the meeting, is clearly a record of the association. And that document gets approved by the full board or the full membership, depending on what kind of minutes it is. So I would normally lean towards the secretary can make any kind of notes they want, whether they're handwritten or they are an audio recording of a meeting. Those are for the secretary's personal use and are not an association record. But I guess part of me would want to know, well, why not share it if it's something like a Zoom meeting recording? But I also know that some people do try and abuse records. So I'd want to know more facts before I gave a legal opinion.
Next one is our association has a standard maintenance contract with a company that also submits fixed priced quotes for special projects on request. I have a feeling as I'm reading this question that it's probably too specific for us to answer here. And so I think for this one, since it's also a little long, if you want to email it to info@condolaw.net, we can look and see if we can add it to next week or if it's too specific. Next one is, what does it mean if an HOA is dissolved and what is the recourse for the reinstatement? So I'm assuming this means if it's been administratively dissolved because you didn't file your corporate renewal on time. And I don't think there's much recourse. You just need to pay to get reinstated. There is a risk if you stay undissolved for liability purposes for the board and accountability, and you may not have the protection of the corporation, but you just have to pay, I think, a higher fee to get reinstated. Ken, do you have any more information on that?
Yeah, the dissolution of the corporation is not the same as the termination of the community as it's been recorded with the plat map or with a declaration of some kind. So the association may lose the corporate shell, and it still is it is still an association, which is a legal entity under common law. And so it can still make decisions, it can still have a board, it can still collect dues. It's just if there were a debt owed by the association, every owner individually could be liable for the full amount rather than the association being responsible. And you may lose the protection of insurance because you don't have the entity to insure. I don't know why the legislature now requires every association to be incorporated as a legal entity. My guess is it's related more to taxes and making sure that the government gets to collect everything they can rather than some other purpose.
The other thing I just thought of is you cannot allow your association to administratively dissolve in an effort to get around complying with the Corporate Transparency Act. There are different requirements for what a dissolved company or one that no longer exists has to do to not comply with the CTA or to be exempt. It's not enough to be administratively dissolved. So you can't just stop filing your annual reports to get out of complying with that. Okay, next question, which we have time for, is it looks like there are changes under SB 5796 or whatever the UKIOA for all bill is for this June, then January 2025, then January 2028. It looks to me like nothing will affect 6434 and 6438 until January of 2028. Can you advise? You are largely correct. The changes that became effective on June 6th of this year only applied to UKIOA. There were some other bills that are effective against RCW 6434 and RCW 6438 that also became effective, but the changes in the UKIOA for all bill were only effective against UKIOA. And so none of those changes, unless the legislature does something different, will become effective against the other statutes and communities until January 1st, 2028.
Yeah, I think there was a legislative error that they did not make the same edits to the Condo Act and HOA Act related to things like voting and secret ballots and records. I think that when they started the session, the UKIOA for all was going to be implemented fairly quickly, and they felt like they didn't need to mess around with the other three statutes. And then during the legislation, they extended the implementation date, and no one looked at the fact that that would mean that the protections they were adding for UKIOA communities in June were not going to apply to any other communities. And I think that there's a chance that we will see in the upcoming legislation session an effort to fix that so that the secret ballots and electronic voting and all those other things will be corrected for HOAs and condos for the upcoming 2 years. I guess the 3 years, 25, 26, and 27.
Right. Well, those are all the questions we had in the chat. So I guess we can let everyone go 2 whole minutes early. And submit your questions by 4 o'clock on Monday for our next one.
All right,
Thank you,
thanks,
everyone.
everyone.